Hello, everybody, and welcome to an introduction to the criminal law. Now, this is going to be the first in a long series of lessons covering criminal law from the perspective of the jurisdiction of England and Wales, and we're going to be doing so over the course of the next few weeks and months. This lesson specifically, though, is going to take an introduction to the subject of the criminal law. We'll also be introducing some of the more theoretical approaches to crime, criminalisation, and criminal theory. This is going to serve as the first major section on our studies, but I'll get to that in a minute when we look at the final slide. Sorry. And we're also just going to be talking a little bit more generally about the nature of crime, the nature of the criminal law, what the purpose of the criminal law is, and some of the ways in which the criminal law has been interpreted through both the eyes of legal theorists, legal scholars, but also through philosophers, sociologists, criminologists, etc., etc., etc. So this is the first of a series of lessons on a new updated series on the criminal law. We are updating all the way to 2023, so we're going to be covering new cases and new crimes that have, or at least new cases that have come out in recent years. And this lesson, as I've said, is going to be taking a major introduction to the subject. Bearing in mind, however, that the first 5 or 6 of these lessons are probably going to be quite introductory in terms of their content and in terms of the approaches that we are going to be looking at. This is because it's important, and one of the things that I want to instill in this new series of lessons on the criminal law is these new theoretical and critical approaches to the idea of the criminal law. Looking at the criminal law not just from a descriptive perspective, but also looking at some of the normative implications. This is something that we look at if you go to our introductory lesson to jurisprudence, which we have done recently as well, when we look at the difference between just simply describing what the law is, describing how the law works, and then also going into and examining the actual normative approaches, i.e., what ought the law be? Why are some parts of the criminal law subject to socio-legal critiques, etc., etc., etc. So all of this is going to be really important in this new series. This does not mean that we're going to just be avoiding the talking about and the discussion of substantive crimes as well. Of course, we're going to be talking about murder, manslaughter, sexual offences. We're going to be talking about principles of essential elements of crimes. So, for example, the actus reus, the mens rea of an offence, causation. But we're also going to be doing so through the lens of more critical approaches as well, as and when we need to actually approach it from a critical understanding. So as an early introduction, let's think about this through the perspective of taking ourselves back all the way away from the substantive crimes themselves, so looking at what murder is, for example. Let's just think, well, what is crime? What is a crime? What does it mean for something to be a crime? Now, you might think that this is a relatively easy an easy question to answer, should I say, especially because for the most part, you would argue that the criminal law is most colloquially well understood and well known. People know what a crime is, for example. Less people will know what it means to say that something is put on trust or something is a tort. Those are areas of law which are, while still very accessible to the general public, they are not as accessible in terms of the sort of deep embedded colloquial understanding as that of crime. Well, despite this fact, and despite the fact that we can all name a crime and we can all define what we think a crime is, the definition of a crime is one which has attracted a lot of debate and deliberation from various different philosophers throughout the centuries, legal theorists throughout the centuries. According to the Oxford English Dictionary, for example, they suggest that a crime, or that the idea of crime, is potentially some kind of act or omission. I've added that bit in there. They've said that essentially an unlawful activity, but I've also made it clear that you can have an omission as part of a crime as well. But they say that it is an act or an omission which is considered to be unlawful. And in addition to this, they suggest that maybe one of the caveats for criminal liability and for a crime is this idea of the unlawful nature of the act or the omission being sufficient to warrant the intervention from the state, or potentially that not necessarily it meets a particular threshold for the intervention of the state, but that the state intervenes and that is what makes something a crime. All of these are generally acceptable theories and generally acceptable definitions. They're not necessarily universally accepted. Some may argue that it is tautological to talk about crime as being, quote, something unlawful, because then you might say, well, what does it mean for something to be unlawful? And you could almost define something being unlawful as something as being a crime. That would sort of blur the lines between the idea of the civil and the criminal in terms of the two jurisdictional elements of the English legal system. But some of these definitions are debated, is the point of this slide. And essentially the idea of what a crime is not universally understood and is not universally accepted. And so we can have general conditions, shall we say, or general features of what a crime may be. So some kind of unlawful act, the intervention of the state prosecuting that individual rather than the individual who is harmed or who is wronged in some way being the person who does the prosecuting, which is of course what happens when we look at civil liability for certain actions. And in this case, you can actually look at quite useful parallels between civil and criminal jurisdictions, because you can look at, for example, certain torts, which can be considered to be both civil and criminal in terms of the actual act itself. So intentional torts such as that of assault and battery will find you will be able to, at least, or there will or could potentially be liability in both civil and criminal jurisdictions. So you might look at that and go, well, the acts are essentially the same. The acts are the same in both of these circumstances. The facts themselves. What is it that makes this one a crime and this one a tort, something that is civilly liable and one that is criminally liable? Most would answer that in the case of the criminal liability for assault or battery, for example, you would say that it is the state that intervenes, rather than in the civil elements of assault and battery within tort, it is the person who is making the claim, who is actually wronged, who is harmed in some way, that can therefore make the claim and sue the defendant. Now, in terms of statute law, there are also definitions of what constitutes a crime, and I've just picked an example here, Section 243, subsection 2 of the Trade Union and Labour Relations Consolidation Act from 1992, where it says that a crime for this purpose means an offence punishable on indictment, or an offence punishable on summary conviction, and for the commission of which the offender is liable under the statute, making the offence punishable to be imprisoned either absolutely or at the discretion of the court as an alternative for some other punishment. Now, this gives a definition of a crime for the purposes of the specific legislation. So this is in relation to trade union and labour law, which is of course something that we are not covering in this series of lessons, as you can imagine. But it also gives us some further delineations relating to what a crime could potentially be, or at least a different way in which we can classify different kinds of crime. You have here, for example, as stated in this particular provision, the idea of an offence being punishable either on indictment or punishable by way of summary conviction. What is the distinction between a summary conviction and an indictment? What is therefore the distinction between the jurisdictions of the various elements of the English judiciary? So for example, that of the Crown Court versus that of magistrates, the lay magistrates. Well, ultimately, this is things that we're going to be talking about in future lessons' time. This is also content and subject matter that we're going to be focusing on when we look in more detail in a series on the English legal system, just as a general introductory legal series as well. So these are things that are going to be covered in far more detail, but I've just put this here as a general indication of how crime is defined in other contexts and in other circumstances, and also how crime can be delineated by way of maybe an offence being punishable on indictment or through a summary conviction. So essentially, what I want to take away from this is this theoretical approach towards criminalisation and criminal offences, the idea of really the debate around what makes something a criminal offence, and then what are potentially the necessary or sufficient factors in the process of criminalization. For those who have never studied or had any kind of interaction with philosophy, the terms necessary and sufficient are philosophical terms. So in terms of what it means for something to be a thing, there are often a lot of conditions attached to the idea of that thing being a thing. So, for example, the idea of a crime being a crime, there are often conditions attached to that. Something is a necessary condition if it is required for that to exist. So if I say that, for example, and this is not necessarily true, but let's just, for a hypothetical example, I say that there has to be some kind of harm in order for something to be a crime, then that would suggest that it is a necessary condition, such that if that condition is not there, then the thing that we are identifying is not a crime. Now, a sufficient condition is one that essentially brings the thing into existence in and of itself. So, for example, I could say, well, what is a crime? Well, a sufficient condition for a crime is that it is either expressed through the common law or through statute or potentially through international treaties, for example, or at least in the context of England and Wales, it would either be through the common law or through statute. Those are actually sufficient conditions for a crime. If Parliament passes a law tomorrow suggesting that, for example, waving to your neighbour is a crime, they have the right to do so through the idea of parliamentary sovereignty, and that would be a sufficient condition for that thing to become a crime. But again, these are very heavily debated. This is going beyond not just the specific doctrinal analysis of criminalization, but also the philosophical and socio-legal approaches to criminalization as well. Does, for example, an act or omission require the person, the perpetrator, to commit some kind of harm? This is what is known as the harm principle. The idea that what makes something a crime is it's an act that causes some kind of harm. Now, there are various pros and cons to this particular approach, and there are various different alternatives and variations on this approach, but this is one of the major approaches within the sort of general philosophy of criminal law. Does an act or omission require the breach of public morals or just general ethics? This is again another major approach known as legal moralism. And again, you can come to a conclusion that actually for something to be a crime, it has to be immoral. Now you're getting into the weeds as to what constitutes something that is immoral there, and people will also come back at you, should I say, with a number of different examples of acts which are probably considered to be immoral but are not considered to be a crime. So, for example, cheating on your significant other would be considered immoral in most circumstances, if not all circumstances, but it is not a crime to do so. So, again, heavily debated in a number of different ways. Does knowledge of wrongdoing matter? Does the perpetrator have to know that what they're doing is wrong in order for that to be considered a crime? This brings into the idea of a guilty mind, the idea of the mens rea of an offence, the intent to commit an offence, versus what is known as strict liability, where intent doesn't necessarily matter. The fact that you did it does not deter. Or at least the fact that you did it and you may have done it not knowing that you have done it, or not knowing that what you had done was a crime, that does not necessarily absolve you from liability. And so, again, does it matter in all contexts? Some crimes are not strict liability, some crimes are. We'll get to which crimes are which as we go on in future lessons. Do all crimes require a victim? If so, what relationship does the state have with that victim in question? And this brings us to another point, which is essentially one of the purposes of the criminal law. And this relates to this approach known as paternalism and a paternalistic outlook towards the state. In a great many different cases within criminal law, it seems to be the case that the state exists to protect those who may be victims of crimes, or essentially to support those who may be victims of crimes, or who have been a victim of a crime in the past. And I guess this all also ties into an idea of a theory of punishment being one to essentially deter people from committing crimes in the first place. You're doing so potentially to protect those who could be the victims of said crimes, and this gives the state a certain idea of paternalism. It gives the state a certain role as being paternalistic. The idea of paternalism is this idea that you limit the autonomy of certain individuals in society's actions, or all of society's actions, and that the justification for doing so is to protect those who are in society who need it most. It is quite paternalistic. And so this is really a question of the relationship between the criminal law and the state, and the relation that those two have with the people and society more generally. Does the state utilize the criminal law and justify the existence of the criminal law on the basis of protecting those in society who need it most? If so, then we are talking about it from a particularly paternalistic standpoint. It's a generally accepted view that when we see the state intervening and instituting criminal offences and prosecuting criminal offences, that they are doing so with the understanding that, and this is a sort of generally understood belief that it is a good thing for society for the state to be able to prosecute those who commit criminal offences, and therefore also have the power to limit the actions of anyone who tries to commit a criminal offence, whether that be through a post hoc prosecution of people who commit that, or even if it maybe deters people from potentially committing it in the future by labeling it as a criminal offence. So this first lesson has been very theoretical, and I'm afraid it's going to be even more theoretical as we go on in the next few lessons' time, but I will just want to outline the scope of this series in more detail here. We're going to be dividing this series into a number of specific sections. Within each of those sections are going to be specific lessons, these sections are going to be highlighted at the start of each lesson, just above the title, as is the case in every single presentation that we do. And the first section is going to be, as you may think already, theories and principles of the criminal law. We're going to talk about some more of the theoretical elements, not going into too much detail as to the philosophy of criminal law, because that is a beast in and of itself, but also talking about the concept of punishment, the idea of evidence within criminal proceedings, the idea of defense, prosecution, the common law system, and just general subsidiary issues relating to criminalization. We will then talk about the question as to what makes a crime. This is going to be a little bit more doctrinal and getting into actually the law itself, the black letter law itself. This section is going to examine the various elements of criminal liability, looking at what it means for something to be a crime, what are required, what are the essential elements for a crime to exist. This involves looking at the concept of the actus reus, the mens rea, the idea of criminal offence or lack thereof in terms of giving rise to criminal liability, the idea of an omission being a crime as opposed to just an act, the causation of the acts and the mens rea towards the actual bringing about of the events that takes place, the concept of strict liability, the concept of secondary participation in criminal liability, so parties to a crime, and then a subsidiary issue in relation to parties to a crime, which is this idea of inchoate liability as well. And then in the third section, we're going to actually get on to using all of the things that we have talked about in these first two sections to apply those to specific criminal offences, talking first about murder, then manslaughter, sexual offences, non-fatal offences, such as assault and battery, for example, and then property offences. We'll spend a lot of time on property offences because they can be divided into a variety of different types. So we're going to be talking about, for example, theft, fraud, making off without payment, burglary, etc., etc., etc. And then finally, we'll talk about defense to criminal liability. These can be broadly delineated into three major categories. We have defenses relating to capacity, so things such as the defense of insanity, intoxication, things like automatism, for example. We also have compulsion related defenses, so things relating to things such as duress, the division between duress by threats and duress by circumstance, and then also the idea of mistake within criminal law.